Hi, thanks for joining us. I'm Jeff Greenbaum. I am the chairman of the Global Advertising Lawyers Alliance and head of public policy for the International Advertising Association. This webinar, which is a global advertising law developments year in review, is kind of our attempt to give you a little bit of insight into some of the key legal developments that are happening around the world. We do a lot of webinars. You can visit the IA's website at IA Global and go to the public policy page and see years worth of videos about a whole host of important advertising law compliance topics. So with that very, very brief introduction, what we're going to do today is we're going to jump in and we're going to, Kiki, are the slides up? Can people see them? I don't think they can. There we go. Okay, so this is our group of speakers, and I will let them introduce themselves as they sort of kick off their sections of this presentation as we go along. So what we're going to do is we're going to talk about really 4 topics today. We're going to give you a little bit of thoughts about each one. If you have questions, depending on the platform you're looking on, you can insert the questions in it, and we'll be happy to answer them as well. And we look forward to talking to you about these issues. So the first thing we're going to talk about today is environmental marketing claims. Certainly a really important topic around the world. There have been a lot of developments, and we want to give you a little bit of an update of some of the important things that have been happening. So, in the United States, when we think about environmental marketing, the first place we look is the FTC's guides for the use of environmental marketing claims. The environmental marketing claims have been around for decades. The FTC announced a review of those guides about a year or two ago, and they have not been updated for more than 10 years at this point. The FTC did hold a workshop on them. They accepted public comments on them, but at this point, they haven't yet released revised versions of the guides. We had been expecting, really, given how long ago that review started, that the FTC would release the guides before the change in administration. That hasn't happened. So at this point, we really have no idea whether the revised guides are going to, in fact, be issued at all, and if so, when. The old guides essentially cover general guidance on making environmental marketing claims, guidance basically discouraging advertisers from making broad environmental benefit claims because of the concern that these kinds of claims, like something being earth-friendly or green, is likely to be misleading to consumers because of its sort of lack of specificity. The guides include guidance on using seals and certifications, and then guidance on very specific advertising claims as well. It's not just about the green guides in the US anymore. 10, 20 years ago, if you were talking about environmental marketing, that's really the only place you would look. Today, there's also states that are issuing specific guidance on the use of environmental marketing claims. So today, when you're thinking about advertising in the US and making environmental marketing claims, it's important to consider the state law issues as well. I guess I would like to just tell you briefly about 2 really interesting issues that are happening in the US right now. The first question is what about aspirational claims? What about claims when you say you're going to be net zero by 2040, or all of your products are going to be recycled by a certain date, or you're going to achieve certain milestones within a particular period? So it's pretty been well settled, particularly at our self-regulatory body, the NAD, that if you're going to make an aspirational claim, a claim about something you're doing in the future, that you need to have substantiation for that claim. And the substantiation that the claim that you would need for an aspirational claim is something along the lines of a reasonable plan that shows that you, in fact, think you will be reasonably able to achieve those goals within the specific time period. And in order to do that, you need to have sufficient data and specific plan in place to show that you can really get there. And what we've seen, though, is we've seen a variety of cases where courts have really struggled with the question of, is an aspirational claim something that is, in fact, a claim that requires substantiation? And we've seen courts go back and forth on this. So just as an example of a case that's pending, the New York Attorney General sued one of the largest meat producers in the United States over its net zero by 2040 claim. The Attorney General's allegations in the case, what was so interesting about it was that the AG really felt that the company hadn't done sufficient due diligence. They hadn't really investigated what their full impact on the environment was. And because of that, they felt like if you don't really understand what your full impact on the environment is, how can you possibly create a plan to show that you're going to achieve those goals by that date? So, the best advice at this moment is if you're making aspirational claims, although there's some uncertainty in the courts about whether those are necessarily claims, and whether they're what type of proof you would, if so, what type of proof you would need, it's probably best to make sure that you're pretty buttoned up in terms of having a plan that is based on, knowing that you're going to be able to get there. And one of the things that the AG pointed to in this case was that although the company was saying they were going to be net zero by that time, they were taking actions that were inconsistent with them being able to achieve those goals. Another really interesting series of cases that are happening right now in the US is, can you promote the good things you're doing if you're also causing harm, right? One of the basic principles of environmental marketing is that, if your product is made of 50% recycled content, it's perfectly permissible to promote that. What we're seeing now, though, in the US is cases like this case that LA County brought against Coke, alleging that, by promoting your recyclable products, you're misleading consumers because essentially you're not disclosing to them all of the other environmental harm that you're causing. A case like this was brought in New York. The court dismissed it, but there's still cases here and others that are pending that really raise this question that if you're in an industry where you're considered to be someone who's really causing environmental harm, without disclosing the harm that you're causing, is even promoting truthful benefits something that's misleading to consumers? Kelly.
Thanks, Jeff. Hi, everyone. Kelly Harris from Harris & Co. in Toronto in Canada. Glad to be here. And in Canada, we also have a lot of updates right now on environmental claims. Last June, we had 2 new greenwashing laws that came into force, which really built upon existing laws that require proper substantiation for advertising claims. And these laws are at the federal level, so they apply across Canada. And there are really high administrative monetary penalties now for breaching these requirements to have adequate and proper substantiation for green claims. So what's new this year is 2 new provisions which specifically regulate claims about protecting, restoring the environment, or mitigating the environmental, social, and ecological causes or effects of climate change. So these are green claims. And what's required are 2 specific claim support standards, both which require what's called adequate and proper testing. And the first new provision applies to the benefit of a product, which includes goods and services, and is essentially, another provision that requires adequate and proper testing for product benefit claims that are green. What's really interesting and new is, and kind of builds on the US requirements regarding aspirational claims, are claims about the benefits of a business or a business activity. So these types of claims also must be supported by adequate and proper substantiation, but in accordance with this new concept, which is called an internationally recognized methodology. And nobody knows what this means yet. This is new in June, and no court has interpreted it. We have some guidance from our enforcement agency, which I'll get into. But really the difference between this new law and the laws that we had before is that it applies to claims about a business. So it's not saying, our product has this environmental benefit. It's, compostable and that's good for the environment. It's about saying something like our business will be net zero by, or is or will be net zero by what date. So it's really a move to regulate business and business activity claims. And the Competition Bureau is the federal law enforcement agency that enforces misleading advertising laws in Canada. And it has developed some guidance specifically about these 2 new green provisions. And the draft guidance dropped in December 2024 and is currently open for comment until the end of February. So if you have a lot of views on this, on advertising green claims in Canada, please give your comments. And some insights from the Bureau from the draft, which sort of indicates how they're going to interpret this. It's not the force of law, but would be, pretty persuasive for our courts, is that a test means a test. So if you have a claim that is making an environmental benefit claim, you can't just rely on a hypothetical or somebody else who did a test. If you're going to make a claim about your product, it needs to be based on a real test. And they're interpreting this internationally recognized methodology, which would apply, of course, to the business or business activity type claims, to mean something, a test that is recognized in 2 or more countries. So, what comes to mind, ISO standards, ASTM standards, these sorts of international standards. And it doesn't need to be the best test. It just needs to be recognized in 2+ countries. And they have given, some consideration to unique Canadian context, mostly as I look out my window at the snow softly falling, our unique geography and our unique climate. So if there is an internationally recognized standard, that could be, in some cases, might be required to be adapted to Canada. So those are the updates. It's a real area of increased enforcement and obviously consumer interest. So something to really watch out for in Canada as well.
So thank you. In the UK, we have, as with many other markets, a sort of self-regulatory system, and we have consumer laws and a sort of legal framework around that. And there are different regulators applying the same rules. Both of them are interested in green claims, and we'll start with consumer law, which are mostly enforced at the moment by the CMA, the Competition and Markets Authority. There's an update on their powers coming up a bit later on, but they're a very serious sort of outfit and a serious regulator. Green claims here have been sort of touted as something that's number one on the agenda for the regulators for 3 or 4 years now. And so investigations have been well underway. And actually now some of those investigations have reached an end. And in 2024, we did have an update on a couple of those. Just to take one step back, we've got, similar to the FTC green codes, we've got our green claims code in the UK, where you can find a lot of useful information. Ours is a bit more up to date on green claims. It's very broad, it covers all sectors, but it's a really good sort of starting point for how the regulators interpret the rules. It has been criticised for being too broad, and it has very extreme examples of something obviously okay and obviously not okay, but all of us live in the middle. So that's been one criticism of it. So when these cases come along, it's actually quite interesting to get some more insights and development on those codes. And that's what happened. One of the investigations the CMA was running into 3 fashion retailers, ASOS, Boohoo, and George at Asda, concluded in early 2024. And off the back of that, we had a fashion supplement that was published by the CMA, which expanded on some of the undertakings that those companies had to give. So the investigation came to an end. There wasn't a ruling on whether or not they breached the rules, but they all agreed under threat of prosecution if they didn't agree to various undertakings to change some of the practices that they were going through. I won't go into all of them in any detail at all, except to say that there are some sort of general guidance that was given that, again, is useful to that sector, but also broader. It emphasized, for example, that we have eco as a phrase is too broad. It doesn't mean anything. You might be able to use sustainable or responsible, but you have to explain in what context you mean those sorts of claims. And if you have a group of products, and this is what all of those companies did, they had a sort of eco range or a green range of products. There are some expectations around those sorts of ranges. You can't completely define it yourself and say, well, if it's got 5% organic fibers, I'm going to include it in my eco range. You have to set reasonable parameters and publish those parameters, make them clear to consumers. And also the CMA turned its attention not only to the fashion retail sector, but more broadly to fast-moving consumer goods, and turned its attention to Unilever specifically. And at the end of 2023, it started investigating Unilever for various green claims. But in November 24, we just had an update on that to say that that has been resolved without Unilever, I think, having to give any undertakings. It was just sort of settled. So that was interesting in and of itself, that some of these cases are being settled. And one of the things they were being investigated for was using natural imagery that exaggerated potentially the sort of natural nature of the product. On the next slide, we've got just a quick example of the ASA. So I mentioned we've got a self-regulatory system as well, as you probably know. It's the ASA that's in charge of that. And the highlights, I guess, of the last 12 months, one of the areas that a lot of markets have been looking at, disposal claims, so recyclable, compostable, renewable, biodegradable, all of those types of claims are under scrutiny in the UK. And the ASA does take a very sort of consumer-friendly, consumer-focused approach. And they're using AI to scan for breaches. So they're reviewing a lot of pieces of content, and we're not waiting nowadays for consumers to complain. The ASA is picking up on these issues by themselves. And just on the last slide for the UK, I wanted to mention one other thing, which is to zone in on a couple of points that Jeff raised for the US. In the UK, similar questions have been considered. So, do aspirational claims require substantiation? The answer is yes in the UK. You need a very firm plan. You need a realistic plan in place. If you're claiming we'll be net zero by 2050, you need a very detailed plan about how you're going to get there, including milestones that are sort of shorter periods of time on the way to 2050. You can't just say, come back to us in 2050 and see if we've succeeded. You've got to have a realistic plan, and you've got to have started on that journey. Again, you can't just make an aspirational claim and sit back and do nothing. And then companies that have gone to trouble for this, HSBC, quite famously a year or so ago, made the claim that they're investing $1 trillion to financing investment globally to help clients reach net zero. They didn't say we're also investing 2 or 3 trillion in companies that are very much not going to be helping the world get towards net zero. And that omission of that disclosure was the problem there. So even though it was aspirational, they hadn't fully set out the parameters around that. And even if you use a sort of third-party trust mark, this is something that the regulators in the UK don't like. Charles Tyrwhitt, the clothing company, used carbon neutral. They claim they are already carbon neutral, but they sell shirts and products that the more you buy, surprise, surprise, the planet doesn't get into a better state. But that's the approach that the regulators in the UK take. So it does have a net negative impact on the environment, even if you offset it. So even if you have a certification from somebody that says, well, we are generally net zero, it's not quite enough to get you off the hook in the UK. So that was just a couple of interesting cases there.
All right, thanks, Garrett. We're going to go back now to Mexico. Jose is with us.
Sorry, guys. I'm sorry, Jeff.
Don't worry. It's all right. Just, you got your slides right there. They should be up. You should be able to see them. You can. We're just kicked off. You can talk about environmental marketing.
Okay, perfect. Sorry, guys. Hi, everybody. So in Mexico, the question is there any specific regulation regarding environmental marketing or green policies? There's no specific regulation, but several laws regulate different topics. The consumer protection law establishes practices regarding false advertisement, and there's has been a lot of new campaigns regarding green marketing in Mexico, but there's nothing yet clear about it. We're trying to push regarding if we can do official standards or Mexican official norms, so we can prevent users from abusing regarding environmental claims and marketing. The authorities regulating environmental issues is Semarnat, which is the environmental authority. They give, or they try to issue different certificates, but the issue here is that there is no linkage between the environmental authority and the consumer protection, and it's something that we're trying to help the authorities to talk more to each other, because if you know, it's useless for Semarnat, which is a company that does not regulate advertising issues, to issue certificates or seals that have something to do with green or environmental issues without giving knowledge to the Consumer Protection Agency that regulates advertising matters. There's a current national development plan in Mexico done by the president. They're pushing it, so there is more promotions, but it has a lot to do with the economic growth with respect to indigenous people, recovery of forests. They are putting a lot of money into this, even though it's something that I don't see that will happen soon. It's just plans, but I think it's something that will be very, very regarding advertising. It's going to be very big or hot in the next 2 years, Jeff.
Great. Okay. Thanks, Jose. So now we're going to. Now we're final final
Yeah.
on. There we go. Okay, Daniel. Sorry.
Back and forth. Great.
Back on track.
Hey everyone. It's great to be here. Great to speak about advertising law with a couple of friends. I'm Daniel Haaien. I'm at Hoge Raad Den Haag, based in Amsterdam, the Netherlands. So yeah, green claims. It's complex. What can I say? And it's as complex in the Netherlands as it is everywhere else. And everybody's looking for guidance, right? So look no further. Our consumer authority, the ACM, has issued guidelines on sustainability claims, which was last updated in June of 2023, actually a while back. But this is actually great guidance. It's also very strict. So if you are looking to be on the safe side, well, then that is the guidance to follow, actually. It features 5 rules of thumb for sustainability claims, being that, well, sustainability claims must be clear, substantiated. If there are comparisons, they have to be fair. And aspirational claims, also, I mean, that's a topic that's in vogue everywhere. So they have to be concrete, they have to be feasible, etc. Concrete ambitions. And if you're using visuals, such as, well, colors, leaves, labels, stuff like that, they have to be helpful and not misleading. What we've seen a lot in the Netherlands is informal enforcement. So there's no fines directly by our authority. Instead, they contact the advertiser, they have a conversation, and it's just really effective because it's a very effective way for this regulator to regulate, because there are settlements, and those can be reached pretty fast, and there have been quite substantial donations to charities, for instance, in light of those settlements. So it's great. Another thing is that there's an upcoming implementation of a new EU directive here in the Netherlands. This is something that's, all over Europe, all over the EU, an important topic, the greenwashing directive. That's new specific rules on greenwashing, which are going to be implemented in the Unfair Commercial Practices Directive. They'll be enforced by September 2026, but there are already regulators, self-regulatory bodies, courts are anticipating the coming into force of those new rules. So they're important. Certain sustainability claims will be prohibited. For instance, doing a generic environmental claim such as green without evidence of excellent recognized environmental performance. Now, what that is, that's actually pretty unclear. In the directive, there's a reference to certain EU regulations and ISO norms, etc. But it's still pretty unclear. Then also expected is the Green Claims Directive. This is still in the phase of a proposal. And that's going to feature a lot of granular rules on substantiation of green claims. It's going to be very strict, and there's going to be an ex ante, so a vetting of environmental claims, actually. So that's going to be pretty intense. Next, in the Netherlands, there's also this issue: can you promote the good you're doing, if you're also causing environmental damage? Well, this was an issue in the first case, actually, about greenwashing before the civil courts here in the Netherlands, between an NGO called Fossilvrij and KLM, our national airline. And one of the claims was, does an airline have to alert consumers about the environmental impact of flying? And the reasoning was, well, no, because the average consumer will know that, that flying is not sustainable. So you don't have to, alert the consumers. You do have to be very careful if you're marketing a very polluting product, then you just have to be very modest in your claims and be extra careful. So that's learning from that case. Same for dairy, is the same as with airlines. The consumer is aware of the harmful effects, but it's not misleading. And then finally, CO2 neutral claims. So like an absolute environmental claim in the Netherlands is very risky indeed. Our self-regulatory body, the Advertising Code Committee here, requires very, very tough evidence. You have to be very robust in your evidence, or else it's not going to fly.
Okay, thanks, Daniel. So now we're gonna, probably you've attended webinars on artificial intelligence before. You've heard about artificial intelligence. There's lots of issues floating around out there. So we're going to try not to talk about the same issues that you've heard about before, but give you a couple interesting updates. In the United States, I would say one of the most significant developments that happened over the last year or so is that 2 states, in essentially strengthening their right of publicity statutes, incorporated artificial intelligence into sort of the protections provided for individuals in terms of controlling their identity. In the Elvis Act, which was passed in Tennessee, it was expanded generally to protect voice, which wasn't originally protected in the right of publicity statutes. And then it also expanded to include sort of essentially technology providers as well, who are providing the ability of people to violate people's right of publicity in this way. California passed 2 statutes. One was expanding rights provided to deceased performance in connection with the use of artificial intelligence. But probably the other one, which is going to have pretty specific impact, was it defined pretty specifically the kinds of consent you needed to get from a performer if you're going to use their likeness or recordings of them for purposes of creating like images of them through artificial intelligence. I mean, the significance of that is that we're sort of starting up specific contracting procedures that you need to follow if you want to comply with California law. I would say, the FTC a year and a half ago was issuing all this guidance about all of the concerns related to artificial intelligence. And, what we saw in the last several months is the FTC started to back up those warnings with enforcement, starting to bring law enforcement actions over, false claims associated with the use of artificial intelligence. So let's go to Canada. Kelly.
Thanks, Jeff. So we've been very active in AI in Canada, but things have sort of stalled out. In 2022, just to catch you up, an AI bill was introduced federally on the back of significant privacy law reforms. And that AI bill sort of set out a lot of obligations for those who are responsible for high impact AI systems, like identifying whether it is one. There wasn't a definition in the bill. And then if you were responsible for a high impact AI system, requirements to establish measures to identify, assess, and mitigate risks of harm and bias, and to establish some compliance obligations and risk mitigation measures. There's also some transparency requirements proposed about publishing how the AI system was used and the kind of content it would generate, as well as the decisions it was making. And there was quite a lot of teeth proposed. So a new AI commissioner and minister to order audits of AI systems, and also some administrative monetary penalties, pretty large ones, up to 3% of global gross revenue. But this was only a draft bill. And since I submitted these slides, we have had some significant federal political upheaval. The governing party has prorogued our parliament to run a leadership race because Justin Trudeau has stepped down as leader of the Liberal Party in Canada. The polls are all over the place, but prior to Justin Trudeau stepping down, it looked like the other party, the Conservatives, were going to be taking away a majority if there was an election called. That's all up in the air. So it's very unclear whether this bill, it's certainly not going to be passed. It's very unlikely to be passed once Parliament comes back into session, as we're probably going to go right into an election, and unclear whether it will be reintroduced if the Conservatives win the federal election. So who knows what's going to happen with AI regulation in Canada. But on the next slide, you'll see that there has been some updates, non-legislative updates, which have been guiding industry, most notably this 2023 voluntary code. So this is just a voluntary code that several large AI industry players have signed onto, which sets out some principles to consider when entering the AI space. So nothing really significantly different than what we're seeing in other jurisdictions, but principles like accountability, safety, fairness, and equity, transparency, humans being involved. For this audience, I think some of the more interesting insights from that voluntary code are transparency. So making sure that it's possible to detect content that's going to be generated by the system. So we're seeing watermarking, ads that are using AI being labeled, that would all be consistent with the voluntary code in Canada. And also to ensure that if you're using AI, not to misrepresent that it's a human. So if you've got a chat bot, make it clear that it's an AI chat bot, and so folks aren't misled into thinking they're speaking to humans. We also have had a little bit of interesting case law in Canada coming out of AI developments. Certainly on the professional side. So, there's, like in other jurisdictions, lawyers getting in trouble for using AI to create their court submissions. But one that I wanted to draw your attention to was a case involving Air Canada, which is an airline in Canada. And they had a chat bot that was engaging with a consumer who, wanted some information about their flight. And they told this consumer that they could apply for a bereavement fare retroactively. And so this was not accurate. And then the consumer sued them and they went to an administrative tribunal. And the tribunal sided clearly with the consumer and gave them $800 in damages because they couldn't get that bereavement fare from Air Canada. And what was interesting here was they held that companies should be taking reasonable care to ensure that their representations are accurate and not misleading. And the fact that you're making this representation through a chatbot is not a get out of jail free card. So an active space in Canada, sort of stalled on the legislative front, but one to watch in the future.
Okay, thanks, Kelly. I'm just moving the slide here. Okay, Jose.
Regarding in Mexico AI, we had an interesting case of a German company that uploaded or advertised a campaign that said in their Instagram page, the best car to drive, or the car is driven very well. At the end, in Mexico, we don't have anything regarding AI, which there's starting to be some bills that come into the equation, but it has nothing to do with advertising. But this is when we did the opinion to the client, we told them you can have a possible issue before the Mexican FTC because it could be a misleading advertisement case. At the end, they brought down the advertising, but at the end, what we have to, in a way, educate our clients is they have to be very truthfulness and transparent about what they're advertising in Mexico. If they're using AI, even though they're using AI, it has to be well advertised, because at the end they can have a lot of issues. Right now with the new administration, I see that there's a lot of interest in enforcing influencers, and the majority of the big companies are using AI with influencers. So this is a very interesting case, Jeff, that did not get to the FTC, but it could have gotten, because at the end we have a guide for influencers like the one in like the one in other jurisdictions, which is not binding, but I think they have to change it in a way because AI is here to stay. So some things that we've seen here in Mexico with the virtual influencers operated by AI is that it's content created with machine learning. We have to know who's the author, who's responsible of the content, the liability of the campaign. Is the AI influencer unable to truly experience a product, like the case that I was telling you with BMW? Is it truthful from an AI made influencer to talk about their experience of driving a car, which obviously is not possible. If the AI generated pictures can misrepresent the product, I think ethical issues in AI are very important. And at the end, there's a lot of targets in campaigns, but AI has been very direct to Generation Z. No?
In the UK,
Yeah, sorry.
Sorry. In the UK, very little to say on AI in a sense. You don't have to disclose by law that you're using AI to use special characters or whatever else in advertising. If you would have otherwise used an actor, it doesn't really make a difference, is the sort of general approach in the UK. An AI created individual who isn't a real individual probably couldn't provide a testimonial to the similar point that Jose is making, but if you're using them as actors or to create the sort of effects in the ad itself, no legal requirement to disclose. Politics has played a role in the UK as well. We're very, very focused at the moment on growth. A year ago, we were focused on creating a lot of regulation. Now we're focused on not applying the regulation and not having the regulators use the powers they were given a year or two ago. So the political sort of chill winds mean that there's not much going on in terms of AI. Just to pick up on a couple of the points that Jeff picked up on for the US, if you were to recreate a famous person using AI, then you would be liable to being sued for passing off in the UK. So if you were pretending that they had given permission when they hadn't, you were just using their clone, as it were, then they'll probably be able to sue you for passing off. And the CAP codes and BCAP codes are not particularly specific on the use of AI. In fact, they're not specific at all. But if you were to use a famous person without their permission on TV, the BCAP code would say that it's prohibited. And on social media and other media, you're only urged or encouraged to get their permission, unless you do something to make them look ridiculous, in which case they would probably complain under the self-regulatory codes as well. And then if you are getting releases for actors, extras, and others that you want to use and in augmented situations or turning them into AI characters using their voice, obviously you'd need to consider licensing and getting releases for those specific purposes. And it is starting to happen. So that's the only thing I want to say for the UK.
Yeah, and so Netherlands has the AI Act right now, so EU AI Act, which is the world's first, I think, comprehensive AI regulation. It's basically a system where it categorizes AI into 4 categories: unacceptable, high risk, limited risk, and minimal risk. Unacceptable are things like social scoring with AI or predictive policing. High risk is in the field of law enforcement or healthcare. Those are regulated. So the unacceptable AI applications are just plain prohibited, and then the high risk is highly regulated. And there are transparency requirements which are relevant for advertising. There's a very broad definition of deepfake. If I heard the word deepfake, I always think about I don't know, some kind of famous politician saying stuff that he wouldn't say. But deepfake in the AI Act is actually an AI generated or altered media resembling real people, objects, places, entities, or even events, falsely perceived as authentic. And there are transparency requirements as to those very broad, as to deepfakes.
Hey, Daniel.
Yeah.
Daniel, so is there a disclosure requirement even if it's not misleading? In other words, if you create an ad that's just a forest,
yes,
and it's not misleading, it's just a forest, so you can put your car in front of it,
yeah,
you'd still need to disclose that.
I mean, so there isn't any case law yet. There isn't any, regulatory action yet. So we really don't know. But that's a really interesting point, and it's a really interesting intersection between, our unfair commercial practices, so misleading advertising, and the transparency requirements under AI regulations. I would say it's completely useless to have a disclosure of, this forest is made with AI. I wouldn't know what purpose that would serve, but that's just my opinion, right? So we also, in our self-regulatory system, we already had some stipulations about AI. It was in our cosmetics products advertising code. So there, I would say it serves a purpose. You know, this fabulous face was made with, you know, with AI. Yeah, if you're advertising cosmetic products, yeah, I can see that.
Okay, so our last topic before we just wrap up with some hot topics is the ever-present issue of endorsers and influencers. So, you know, in the U.S., like with the green guides, we also have FTC guides governing the use of endorsements and testimonials in advertising. The key thing to understand about these kinds of guides is they're simply the FTC's view about the types of practices that would be illegal under Section 5 of the FTC Act, which prohibits unfair or deceptive acts or practices. They're not regulations in and of themselves, but they are guidance about what the FTC thinks is deceptive. Interestingly, though, and the significance of these guides and the significance of violating Section 5 is that ordinarily, if you violate Section 5, the FTC can tell you to stop, can prohibit you from doing it in the future, but they can't get penalties. And so one of the things the last FTC did, and remember, it's probably lost on nobody that the administration has changed in the United States. And along with the presidential administration changing, the leadership of the FTC has changed as well. But the prior FTC leadership really led the creation of a lot of rules that either built upon existing guidance or codified existing guidance. And the significance of that is that if you violate a rule as opposed to a guide or the FTC Act itself, you can be held liable for civil penalties. And the civil penalties can be substantial, like upwards of $50,000 a violation. And if you're calculating that based on the number of consumers, for example, that have been harmed, the damages can get really big really fast. So one of the most important things I want to say without rehashing the sort of familiar guidance about the use of endorsements and testimonials is that now with the trade regulation rule on consumer reviews and testimonials, many of the practices that had been sort of prohibited in an advisory capacity under the endorsement guides are now prohibited for real, meaning that if you violate them, you're subject to penalties. Bottom line, what's prohibited in the U.S. when we talk about endorsements? Number one, if you're going to review a product as an endorser or an influencer, you got to make sure that the endorsement is honest. That means if you have to give your honest opinions. If you say you're a user of the product, you have to be a real user of the product. Second, if you make claims about product performance, those claims should represent the generally expected performance. And finally, it should come as no surprise to anybody that if you're speaking on behalf of a brand, it needs to be clear that you're speaking on behalf of a brand. The idea is that if there's a material connection between you and a brand that is not reasonably expected by the audience, that needs to be disclosed so consumers understand the source of who is speaking. Just in terms of some examples of the kinds of cases that are happening right now, the FTC brought a case against CarShield, and what's interesting about this case is that this wasn't the sort of material connection disclosure case where we've seen the FTC focusing on that a lot. This was a case where the FTC went after the advertiser because they used celebrity endorsers who claimed they used the product, but they hadn't in fact used the product. $10 million settlement. It's not just the FTC, however. There was a multi-state settlement with Cameo. That's like the video service where you can go and get someone famous to send you a happy birthday message. They also have a business video service where companies can go and ask celebrities to record videos for them. And the issue there was that Cameo didn't have processes in place, at least according to the AGs, that got those celebrities to make sure that they were including disclosures in those videos so that it was clear that they were speaking on behalf of the brand. Kelly?
Thank you. So in Canada, we've got a number of laws and self-regulatory rules about influencers and testimonials, most notably under the Competition Act, which is our federal misleading advertising law. There is a requirement if you want to use a testimonial to either for the testimonial to have been previously published, or you need to have a written agreement to use the testimonial if it hasn't been previously published. So that's a statutory obligation, in addition to ensuring that you're not using a testimonial or endorsement in a way that's materially false or misleading. We don't have a ton of enforcement actions in this space. The key one is really old, from 10 years ago, and this fell it wasn't even an enforcement, it's a consent agreement. So it's sort of like a settlement between the Competition Bureau and the, in this case, Bell, which is a telecommunications company. And at issue here were reviews that Bell employees were posting on the Google and Apple app stores about some free apps of Bell's. So it's kind of a weird situation where, you know, they were posting on these app stores for an app that wasn't even a paid for app, but they didn't disclose that they were employees. So it wasn't at all an issue that these weren't the honest opinions of these individuals for posting. The issue was that they didn't say, by the way, I'm an employee of Bell. And this kind of came to light through a blog post. So it was the Bureau was kind of forced into doing something about it. And in any event, Bell entered into a $1.25 million administrative monetary penalty for this. So it is a space that has been enforced against, but there hasn't been a lot. On the influencer side specifically, there were some warning letters that were sent in a few years ago, warning businesses and influencers about, you know, making sure that they're disclosing material connections, but there hasn't been a lot of actual enforcement. One thing to watch out for is the new Consumer Protection Act in Ontario, which specifically prohibits a consumer contractual term that tries to prevent a consumer from publishing or communicating their review. So that is prohibited and in Ontario now under the new consumer protection law that was passed last year. We also have some self-regulation. Ad Standards is a national self-regulatory body for advertising in Canada. There's a particular clause in their code which requires testimonials and endorsements to be true. And there is a requirement to disclose a material connection under the self-regulatory code, which is enforced through consumer complaints and trade disputes. There's also obviously under Canadian law an interplay here with personality rights. So if you're trying to use a testimonial in your advertising, you have to make sure that you're getting consent and agreement from, you know, the individual, because people have the right to commercialize their own persona. There is a little bit of guidance. And if you look on the next slide, the Competition Bureau, which is our federal law enforcement agency, kind of like the FTC, has given some digests and checklists in their digests about how to make sure that you're properly disclosing a material connection. Really, this is #ad. It's a little bit less prescriptive than in the US. So the Bureau's guidance is really flexible, saying that, you know, you can just make sure that it's contextually appropriate and that it's inseparable, that it's on, you know, based on actual experiences, and avoid ambiguous references like thank you or, you know, partner. And you want to make sure that it's as visible as possible, but it's a little bit more flexible than the US standard. And if you're looking for more concrete guidance on what would fly in Canada for these kinds of material disclosures, you can look to Ad Standards. They've got a set of disclosure guidelines that really get into the weeds with particular platforms and their recommendations for ensuring that your disclosure is going to be appropriate.
Jose. Jose, I think you're on mute.
Oh, sorry. Regarding reviews in Mexico generated by virtual influencers, we're seeing a lot of the companies doing these reviews with virtual influencers. The thing here is, here's two examples of actual companies saying that it's because the review is generated by AI, because they've been having having not lawsuits before the FTC, but yes, maybe cease and desist letters from the authority saying you have to be very truthfulness regarding what you are saying and what are the reviews. Here, the biggest problem in Mexico is that consumer reviews are not regulated, and at the end, anybody can say whatever they want in a way reviewing the company. So we're like in the limbo of what's going to happen in the near future, because this is happening over and over again with a lot of companies that are direct competitors, and obviously we don't know that they're behind the reviews, but they're always not saying very good things of these big companies that are doing very well. Right now, in the next 2 years, we're gonna have the World Cup. It's gonna be very interesting if we have any type of regulation regarding reviews, and the relationship with AI, because at the end there's going to be so much campaigns, companies, and publicity from everywhere coming into Mexico, that if we don't have guidelines establishing the limits for the companies, it's going to be mayhem here in Mexico. So regarding this, what I was mentioning about how to regulate contacts between consumers and influencers and AI, I think these are talking points that we've been talking with the authorities. Yesterday, we had a meeting with the General Counsel of the Mexican FTC. We told them about these issues. It wasn't in their priorities. There's other priorities, but I think that bringing this to the attention of the authority is going to make that we start having some enforcement about it. But like we were talking about the dark patterns, how can we avoid dark patterns? Unfortunately, they didn't know what was dark patterns. We were talking to them a little bit about what was it, and when we told them about it, they said, come to the office, talk to us about it, because it's very important. Obviously, there's a lot of work. There's very few people, and I think Mexico is going to be very interesting. In the agenda of the new president, there is a lot of interest in the Consumer Protection Agency and the Mexican PTO. So I think we have a good panorama for the next 2 years.
Okay, Garen.
Thank you. Yes, influencer marketing, it's still high on the agenda of the ASA in the UK, not so much the other regulators, but the ASA is still paying attention. It's still issuing updated guidance every couple of years. One of the latest things that it's got to be in its bonnet about is where there's a commercial connection between the influencer and the brand that's not being disclosed, which is the usual sort of hashtag ad thing that I'm not going to talk about because we've talked about that for years and it's been done to death. But in this instance, Grace Beverley, who's an influencer, she hadn't disclosed on her own sort of platform, on her own feed, that she was creating this commercial content, but she owned this company called Tala. And normally, if you're a brand or a retailer, you don't have to disclose the fact you've used an influencer in your sort of social post because it's pretty obvious. But in this case, because there was that crossover and they both posted it and she owns Tala, they both should have had a disclosure and they didn't. Even though it was obvious from the rest of the content what she was doing. She was flogging all of these items of clothing that she had designed and being quite open about it, but she was missing the disclosure before anybody engaged with it. And on the next slide, we've got another relevant example. This is Stephen Bartlett, who you've probably all got your own versions of Dragon's Den, but he was in our version of Dragon's Den as an investor. And he had invested in both of these companies, Huel and Zoe. And both of them ran social media ads where it had a sort of quote from him. This is Huel's best product, Stephen Bartlett. And similarly with Zoe, if you haven't tried Zoe yet, give it a shot. It might just change your life. The regulator said this looks like a testimonial, but it doesn't look like you're disclosing the fact that he has a small sort of shareholding in both of those companies.
Garrett, so yeah. It's like Shark Tank.
Exactly. Yeah.
I had to Google it. I was like,
sorry,
what's Dragon's Den?
I was in the same boat.
It's Dragon's Den in Canada, so you're with us, Garen.
Perfect.
Dragon's Den in Netherlands as well.
There you are. There you are. I didn't know it was going to bind us or divide us, but there we are. So yes, it's all about just making that clear. And that could have been fixed quite easily just by saying Stephen Bartlett, proud investor, let's say in brackets or whatever, just next to his quote. And then finally on the in the UK, I just wanted to mention on the next slide, there is also, when it comes to influencers, finfluencers, financial influencers, new rules here. So you're not going to see, in the way that we did a while ago, influencers promoting all sorts of complex investment products, including crypto style investment products that they know nothing about or they've set up themselves. Again, I'm not going to make any cheap jokes about any new coins that might have been minted recently. But there are specific rules here around influencers no longer sort of promoting these sorts of things. And the rule is there's a criminal offence and it could end up with a 2-year prison sentence. And some influencers are actually being prosecuted as we speak. In fact, the case is taking a long time to come to trial and it will take another sort of year or two. So the regulators, I think, just wanted to initiate proceedings to make clear that they are taking these seriously. And in this instance, it's the FCA, the Financial Conduct Authority, that's in charge of that. So serious stuff. Influencers should not be promoting complex financial investments and products in the UK.
Right. So I'm just going to point out very quickly a couple of helpful sources for guidance here in the Netherlands. We have the ACM's Guidelines on the Protection of the Online Consumer, which contains guidance on online influencing, use of reviews. There is the Unfair Commercial Practices Act here, and there was an implementation of a EU directive, the Modernization Directive, which explicitly prohibited fake reviews. So nothing new, but an explicit prohibition. So, and we have our self-regulatory advertising code, social media and influencer marketing. That's really specific rules on disclosures, etc. And then lastly, I wanted to point out the European guidance on influencers. There's actually an influencer legal hub launched by the European Commission. And it contains fun clips and lots of good explanation on the appliance of unfair commercial practices rules on influencing. So if we go to the next slide, a couple of developments here in the Netherlands. Our Dutch Media Authority has issued the first fine, not like 10 million or 20 million the way it is in the US, but 6,000 euros. But the thing is, the Dutch Media Authority wasn't the regulator for influencers, and they can be a regulator now if it's a commercial media service on demand. That's a new development. Next, certified influencers. There's actually an influencer certification, which is great. And yeah, check it out. Certified by influencerregels.com. Thanks. Back to you, Jeff.
All right, thanks, Daniel. So in the remaining couple minutes we have left, we're just going to spend a minute and highlight for you a hot topic or two that are other things to be thinking about. What I just want to say about dark patterns is, FTC issued a report on dark patterns. It was very philosophical about the kinds of online design practices that can harm consumers. And what we saw over the last couple of years is the FTC sort of take that philosophical framework and really put it into practice. We saw the FTC do two rulemakings, the click to cancel rule, the junk fees rule, and we saw enforcement in that area as well. So I would pay strong attention to dark practices. Unclear what the new administration is going to do on this front, but certainly we saw the FTC take a very big step from just raising the concerns to really changing the law on this issue and then bringing enforcement actions.
And in Canada, we're seeing a real trend of penalties skyrocketing. So 2 years ago, the maximum federal penalties increased to the greater of 10 million Canadian, or 3 times the value of the benefit obtained. And if it's not possible to quantify the benefit, that can go up to 3% of annual global gross revenues. So we've just seen enforcement under these increased federal penalties in the fall, and Cineplex was the unlucky recipient of a almost $39 million Canadian administrative monetary penalty. And this was in the case of drip pricing. So the amount of penalty was determined based on the dripped price of $1.50 per booking fee by the number of people who had a transaction during the investigated 2-year time period. So it's very high in terms of the monetary risk. And on the next slide, you'll see there's also an incoming risk of private suits in Canada. So right now, it's just the Competition Bureau who can get those really big increased penalties. But as of June, a private litigant could go to the Competition Tribunal, which is a specialized adjudicative body, and submit an application under those exact same laws, seeking those exact same remedies. The only bar to them doing so is to get leave of the Competition Tribunal, which it will grant if it thinks the case is in the public interest. Again, nobody knows what that means yet. It's not a term that has been judicially under the Competition Act before. So the other consideration under this is that those penalties would still be monetary penalties going to the Receiver General. So it's not like the litigant would get that money if they were awarded an administrative monetary penalty. So the litigants would need to be well funded, but this is a huge area of unknown risk that's going to be coming into force in June.
Thanks, Kelly.
For Mexico, obviously the hot topic is influencer guidelines. Like I was mentioning, there in 2014, in 2024, they brought it into effect, but it's not binding. What we try to do, or we're trying to convince the authorities to modify the law. Like all of my colleagues here present, you know that there's just one article in our consumer protection law regulating advertising. So the idea is to put more responsibilities for the advertisers, for the agencies, for the media hubs. Certain type of products must comply with special regulations, but at the end, it's not very clear in the law. So I think it's a job of working with associations, with private practice, and with authorities to try to modify how the influencers can advertise. Something else regarding a hot topic will be ambush marketing in the next 2 years with the World Cup. It's going to be very important. Again, the key players from the industry help the authority to try to prevent all of these ambush marketing that will be very big here when the World Cup starts.
Thanks, Jose.
Thank you.
Jared?
In the UK, the big news is big fines. So in Canada, you might be fined 3% of annual global turnover, but in the UK, you can be fined 10% of annual global turnover from April this year. We've got a new Consumer Law Act that's coming in, the DMCC. This replaces the sort of European model that we had before. And if you continue to breach the rules along the way, then you can have daily fines also of 1 to 5% of daily global turnover. The CMA will be able to bring these sorts of investigations unilaterally without having to go to the courts. So it is getting really strong new powers, and their focus is very much on price claims, discount claims in particular, and drip pricing. They're also looking at fake urgency claims, and fake reviews is also number one on the agenda. That's become a strict liability offence to host fake reviews. So that's something that we're talking to clients about. And Oasis tickets. Oasis fans might have seen that there was lots of controversy around sales of Oasis tickets. People were sort of being held in queues for 2 or 3 hours, then told they've got 2 minutes to pay twice as much as they thought, 3 times as much as they thought they were going to have to pay. So a combination of drip pricing and urgency going on there for dynamic pricing. And so the CMA has also been looking into that sort of practice as well.
And finally, Daniel?
Yeah, thanks. Well, children's marketing is under scrutiny, shrinkflation is under scrutiny, but the really big news here in the Netherlands and the EU is the next slide, which is a very interesting case about the average consumer, which is basically our cornerstone of advertising law. Should the average consumer, which is like a fictive person, should that standard incorporate insights from behavioral economics? And there's actually now some more room for reality to kick in with our average consumer. So our average consumer is going to be less circumspect, less smart, so to say, and he will be more easily misled, probably. We have still to see like the fallout of this big case, but it's a major development here in the EU.
That's so interesting because there's been some cases recently in the U.S. where actually we've gone in the other direction, where courts have actually sort of said that the consumer is not the reasonable consumer, or a reasonable consumer is actually more knowledgeable than we thought in the past. Anyway, very, very interesting that everyone's still struggling with this. So anyway, thanks everyone for joining. If you want more information, you should check out the IAA's public policy website, which has all kinds of videos and great resources. The Global Advertising Lawyers Alliance publishes a blog where almost daily we're reporting on these kinds of developments around the world, or you can go check out any of the firm's websites and get sort of country-specific information. So thanks again, everyone, for joining. We really appreciate it, and we'll look forward to seeing you at the next IA webinar.
Thank you, guys. Sorry for my tardiness.
Bye, everyone.
Bye.
Bye.